Non-compete agreements. How much is too much? In this video, I'm going to be talking about non-compete agreements. The question that we need to ask ourselves while we protect our rights to non-competition is, how much is too much? What I seek to question is not the legal provisions regarding non-compete agreements, but what we seek to question is how much do we use and how much do we overuse these provisions. This video is going to look at more of the question of the ethical considerations that we need to keep in mind in non-compete agreements. This video is going to be a two-part session. The first video is going to be the constitutional provisions and the human rights perspective on non-compete agreements. The second video is going to be the session on the contractual parts of it. We live in a free economy. We live in a world where competition is a normal part of life. The question that comes in now is we also try to restrict competition in order to secure our business interests. Now when we look at this, the fundamental things that we need to consider is, are we violating somebody else's human rights? Are we going overboard on our contractual relations to suppress or obstruct somebody else's free trade and profession? And these are questions that we need to discuss. These are things that over the next two videos we will discuss and consider, and the questions are up to each and every one of us to answer. We all are so full of having non-compete agreements signed. Every organization, every company, everybody needs to look at a non-compete agreement in this day and age, in this business environment. But what is a non-compete agreement? Let us first understand that. When we look at a non-compete agreement, let's take the Black's Dictionary's definition of a non-compete agreement. The Black's Dictionary defines it as a promise, usually in the sale of business or partnership or in an employment contract, not to engage in the same type of business for a stated period of time in the same market as the buyer or employer. And these are things that you need to look at. It's a promise, usually in a sale of business or partnership or an employment contract, not to engage, and I repeat, not to engage in a certain type of business or the same type of business as the employer or the buyer for a stated period of time, which means we need to consider the tenure of this agreement. How long is a person barred from non-competition? And in the same market. So when you look at the same market, what you're also looking at is the territorial jurisdiction or the territorial extent of such a contract. The next question is, do we need it or not? Why do we need it if we need it? And what are the purposes of non-compete agreements? Non-competition is increasing because business mergers and acquisitions, takeovers, amalgamations, the increase in contractual employment on the rise, and of course the use of external professionals, specific professions like for instance consultants, web developers, website builders, and all of these, that you have external professionals coming into your organization to work on specific limited assignments or specific limited projects. These would result in the need for non-compete agreements. But we need to look at the ethical considerations when we talk about non-compete. I will now move on to the constitutional aspects of non-compete agreements. Let us first take Article 19(1)(g), which provides every Indian citizen the freedom of business, trade, profession, and occupation. So, well, it is a fundamental freedom to enjoy the option or the choice of business, trade, profession, or occupation. This would mean unhindered operations of or unhindered freedoms of your freedoms of business, trade, profession, or occupation. However, it is subject to reasonable restrictions, and contractual obligations would also form part of these reasonable restrictions, apart from the legal restrictions put on by statute. However, when we look at these reasonable restrictions, what we really need to look at is whether these business environments are fair, whether we are playing on a level playing ground. Because what really happens is, more often than not, when it comes to employment contracts or when it comes to buyouts, does the person who is selling out or does the employee really play on a level field? Does that person really have equal opportunity of vetting the contract, of actually checking each clause and modifying it to his own convenience? Or whether it is a pro forma contract, it is a contract that is drafted by the other side and just put to him and he's made to sign on the dotted lines. Now, when we are doing such contracts, we need to really understand its implications both on ourselves as well as on the other parties, so that it is a fair and mutually acceptable contract to both sides. While we consider the right to trade and profession, while we secure the interest of businesses and large corporate houses, there is also the question of the employee or the independent professional that is working with these firms that also need to be considered. We also need to look into the angle, because they are as much citizens of India as the persons who are signing the contract. They are also citizens of India, entitled to the same freedom of trade and profession that all of us are subject to. And a draconian non-compete clause would actually defeat this purpose. A draconian non-compete clause would actually deprive them of their freedoms. We will now need to look at the two aspects that we spoke about earlier. One, the territorial jurisdiction of the contract or the territorial extent of the contract, and the time limit or the duration or tenure of the non-compete agreement. Let us take up the issue of the territorial aspect first. If the contract or the non-compete agreement operates only for a limited area in which the employer conducts his business or operates, it could be considered reasonable. But if it is for an indefinite area, no specified area, this could be extremely restrictive. This could be actually violating the other party's right to trade, profession, or occupation. When you then look at the aspect of tenure, the question is how long? Because if it is something that is too long, if the non-compete agreement is ad infinitum, or if it is for an extremely long period of time, this would also operate as a violation of the freedom of trade and profession. This would infringe on the other party's rights to trade and profession. However, if it is for a limited period of time to secure business interest, this would be rather fair. Let us then look at the next major issue that we come in, and this is from a constitutional perspective. Article 21, right to life, right to protection from deprivation of life, and of course, the expanded definitions to Article 21. Now, when we look at this, several judgments of the Honorable Supreme Court of India, as well as the various high courts of states, have already expanded the definition to right to life. All of this has spoken about not only the mere existence or the mere ability to live, but also the ability to enjoy a healthy standard of living, and which includes the ability to a means of livelihood, the ability to earn an income in order to enjoy a decent standard of living. And these are things that have to be considered. So when we get into extremely draconian or extremely stringent non-compete clauses, what we'll end up doing is depriving people of their trade profession, and eventually, if it's that bad, you could be depriving somebody of his right to livelihood. And let me give you an example, because when non-compete agreements become so pervasive and when they become so extensive, what really happens is people can be deprived of their right to life. And let us take an example of any of us from the legal profession. Tomorrow, if I sign a contract with a law firm or any other company or any other client for that matter, saying that post this assignment, I will not be able to practice, even if it means for the next 10 years, practice in the legal profession or have anything to do directly or indirectly with the legal profession or with the paralegal industry. In such a case, imagine what would I do? For a person who spent his entire life in the legal profession, for a person who has trained in the legal practice, how would I then construct a new means of livelihood? How would I then go to a new job or a new occupation and start all over again? So if a non-compete agreement is actually that exhaustive, it may actually restrict a person's freedom of trade and profession as well as his right to life and livelihood. The last aspect of constitutional law that I would like to take up and correlate with non-compete agreements is equality and equality of opportunity. When we look at it from the constitutional perspective, the preamble to the Indian Constitution clearly spells out the principles of equality, both financial, social, and otherwise. When you then look at it from the perspectives of Articles 14 and 15 of the Indian Constitution, you also have the concepts of equal protection of law, equality before law, and protection from discrimination. Now, the question that we need to take from this is not the pure sense, but the question of whether each of these parties to a non-compete agreement is actually playing on a level playing ground, or whether each party has equal opportunity of negotiating the contract, or what we may broadly consider equality of opportunity. While we look at the aspect of social and economic justice, the fundamental question that I'm raising, the fundamental ethical consideration that I'm raising, is generally an employee or a person selling out of necessity may not really be in a position to negotiate these contracts, may not be in a position to actually check or have a say in each and every clause of the contract. More often than not, these people have limited and restricted choices where they're just about compelled to sign on the dotted line. Now, in such a case, the question that comes in is, are they provided with equality of opportunity? And these are things that we really need to look at from an ethical point of view as well as a legal point of view before we sign or before we draft non-compete agreements. There is a whole gamut to contractual obligations in non-compete agreements, but I will take up the entire aspect of contractual obligations in my next video. Do subscribe and stay tuned to my channel for more information on the second video, which is connected to non-compete agreements.